Good afternoon. My name is Owen McDonough, Senior Science Advisor to the Assistant Administrator for EPA's Office of Water. I want to thank you for your time and your interest in today's webcast on the final Navigable Waters Protection Rule, which revises the regulations defining waters of the United States and the scope of federal jurisdiction under the Clean Water Act. On June 22nd, the Navigable Waters Protection Rule became effective in all states and jurisdictions except for the state of Colorado due to a court-issued stay in that state. The EPA and the Department of the Army are hosting this series of webcasts to highlight key elements of the final rule and how it will be implemented. Today's session is the fifth and final session in the series and discusses exclusions from the definition of waters of the United States, the jurisdictional determination process, and implementation updates, including aquatic resource mapping. This webcast is being recorded and will be hosted on the agency's websites for later access. The final rule reflects legal precedent set by key Supreme Court cases, as well as robust public outreach and engagement, including significant pre-proposal input and over 620,000 comments received on the proposed rule. The agencies have streamlined the definition of WOTUS to include 4 clear categories of jurisdictional waters, to provide specific exclusions for many water features that traditionally have not been federally regulated, and to define terms in the regulatory text that have never been defined before. I'm pleased to note that EPA has worked side by side with our partners at the Department of the Army throughout the 2-step WOTUS rulemaking process. Matt Wilson, Regulatory Program Manager for the U.S. Army Corps of Engineers, is on the line to answer questions following the presentation. I'll now turn the meeting over to Ms. Stacey Jensen, Assistant for Regulatory and Tribal Affairs for Army Civil Works, and Ms. Mindy Eisenberg, Associate Director of the Oceans, Wetlands, and Communities Division at EPA's Office of Water, to walk through the provisions of the final rule relating to exclusions. Mindy?
Thanks, Owen. You should be connected to this webinar through your computer. At this time, you should see a slide that is titled Webinar Logistics. You can listen to this webinar's audio through your computer or by dialing into the call-in number. The call-in number is 650-479-3208, and the access code is 127-783-9640. Please note that due to the large number of participants, questions will only be accepted in writing through the platform, so you do not need to call in. Once you are connected to the audio, if you hear an echo, please turn off your computer speakers. All participants have been automatically muted to avoid any echo and sound issues. If you are not able to connect to the WebEx platform and therefore cannot view the presentations, you can still listen in through the phone and you will be able to hear the presentations from your speakers. If you have any technical difficulties, please send an email to epa@horsleyWitten.com. Again, that is epa@horsleyWitten.com. This webinar is being recorded. If you would like to view the presentations larger than what is shown in the webinar screen box, please select View from the menu in the upper left-hand corner as shown by the red circle on this slide. Once the menu drops down, select Full Screen. Once you are in the full screen mode, you can zoom in and out of the view by clicking on the plus or minus buttons on the left-hand side in the gray bar. To return back to the previous normal screen mode, use the icon in the upper right-hand corner of your screen. You will need to do this in order to ask questions through the questions box. We welcome questions from our participants. In order to ask a question, please use the question box as opposed to the chat box. If the Q&A box is not already located at the right of your screen, please navigate to the icon indicated at the bottom of your screen and select the icon with the 3 dots on it. Click on this icon and select Q&A. Once the Q&A box has appeared on your screen, Type your question in the message box after clicking on the arrow to the left of the Q&A in the box. Make sure that you ask all panelists. This setting will ensure that all speakers see your question. Hit send when you are ready to submit the question. Note that your submitted question will only be seen by the panelists. Your question will be read aloud at the end of the presentation, and the speakers will answer. Depending on time, not all questions may be answered. As Owen mentioned, this week's webinar is our final webinar in the series. If you missed the previous webinars in this series, we will be posting the recordings on EPA's website shortly. Today's webinar concludes the series by providing an in-depth look at the waters and features that are excluded from the definition of waters of the United States under the Navigable Water Protection Rule, as well as an overview of the Corps' jurisdictional determination process, the implementation memoranda being developed by the agencies, and the agency's Aquatic Resource Mapping Initiative. Then we will provide time for questions through the Q&A box. Let's start by discussing the difference between an exclusion and an exemption. The Navigable Waters Protection Rule identifies exclusions which eliminate certain waters from the definition of waters of the United States. Excluded waters and features are not jurisdictional. We will be discussing these regulatory exclusions from the definition of waters of the United States throughout today's presentation. Exemptions are activities or discharges that are exempt from Clean Water Act permitting requirements. So a permit is not needed to perform an activity that is exempt in a jurisdictional water. Exemptions are described in Section 404F of the Clean Water Act, and the Navigable Waters Protection Rule does not address activity exemptions under Section 404F, including those for normal farming, ranching, and silviculture activities as part of an established farming operation. The Clean Water Act also excludes certain discharges from the definition of point source. These discharges that do not require NPDES permit coverage. These exclusions are different from exclusions from the definition of waters of the United States, and thus are not the focus of today's presentation. They are not addressed by the Navigable Waters Protection Rule. The exclusions in the rule are identified in the Corps' regulations at 33 CFR 328.3b and in EPA's regulations at 40 CFR 120.22. For convenience, we will generally refer to the Corps' regulations throughout this presentation, and thus will refer to exclusions as paragraph B of the rule. For reference, paragraph A identifies the waters of the United States, and paragraph C defines applicable terms in the rule. As we have discussed in this webinar series, the Navigable Waters Protection Rule codifies 12 exclusions to provide clarity and regulatory certainty regarding the scope of waters federally regulated under the Clean Water Act. Paragraph B1 of the rule excludes from the definition of waters of the United States all waters that are not A1, A2, A3, or A4 waters. This approach comprehensively excludes all waters and features that are not included as waters of the United States under paragraph A of the rule. In addition to this overarching exclusion, the rule adds exclusions in paragraphs B2 through B12 to provide more specificity for certain common landscape features and land areas that are not jurisdictional. However, the rule maintains a list of specific excluded waters in paragraphs B2 through 12, even when they may overlap with paragraph B1, because these specific exclusions provide additional clarity and regulatory certainty. It's possible for a water or feature to meet more than one of the exclusions in paragraph B2 through 12. It is also important to understand that waters that are excluded under paragraph B cannot be determined to be jurisdictional under any of the categories of waters of the United States in paragraph A except where otherwise indicated. While the final rule identifies 12 exclusions, many of the exclusions reflect longstanding agency practice. For example, to ensure predictability, many waters generally referred to as preamble waters under the agency's 1986 and 1988 regulations are now expressly excluded in the rule. Additionally, exclusions for waste treatment systems and prior converted cropland, which have been included in regulatory text for decades, are now defined for the first time in the rule. And just a note, for purposes of this presentation and discussion, paragraph B refers to waters and features that are non-jurisdictional and excluded from the definition of waters of the United States. This presentation will collectively refer to waters and features as simply waters for brevity and simplicity. The next two slides introduce the 12 exclusions found in paragraph B of the rule. Following these two slides, we'll walk through some considerations to keep in mind when evaluating exclusions and then go through each exclusion to give an overview of the waters excluded from the definition of waters of the United States. The names on this slide and the next are shorthand descriptions of the exclusions for simplicity. Please refer to the Navigable Water Protection Rule for the full text of each exclusion. The B1 exclusion addresses waters that are not identified in paragraph A. This is the overarching exclusion that I just discussed. The B2 through B6 exclusions include groundwater, ephemeral features, diffuse stormwater runoff and directional sheet flow, certain ditches, and prior converted cropland. The next 6 exclusions include artificially irrigated areas, artificial lakes and ponds, water-filled depressions, stormwater control features, groundwater recharge, water reuse and wastewater recycling structures, and waste treatment systems. It is important to note that the Navigable Waters Protection Rule defines upland in order to improve regulatory predictability and clarity. Upland means any land area that under normal circumstances does not satisfy all 3 wetland factors identified in paragraph C16 of the rule and does not lie below the ordinary high water mark or the high tide line of a jurisdictional water. Based on this definition in the rule, upland refers to any land area that does not meet the regulatory definition of wetlands and does not contain jurisdictional waters. Several exclusions refer to waters constructed or excavated in upland or in non-jurisdictional waters. For these exclusions, the waters must have been constructed or excavated wholly in upland or wholly in non-jurisdictional waters for the exclusion to apply. Where a water is constructed or excavated wholly in upland or non-jurisdictional waters, the mere interface with a jurisdictional water does not make the excluded water jurisdictional. For example, a ditch constructed or excavated wholly in upland that connects to a tributary would not be considered a jurisdictional ditch. Before going through an overview of each exclusion, it should be noted that some excluded waters can provide a surface water connection between upstream relatively permanent waters and downstream jurisdictional waters sufficient to support jurisdiction of the upstream waters. That is, some of the exclusions, such as channelized ephemeral streams, can provide a surface water connection between an upstream reach of a jurisdictional water and a downstream jurisdictional water, such that the upstream reach is jurisdictional, even though the channelized ephemeral stream would remain non-jurisdictional. And when determining if a water meets a given exclusion, it may be necessary to conduct a typical year assessment in order to evaluate the flow conditions of a reach in a typical year or to document the extent of flooding from a paragraph A1 through 3 water in a typical year. For example, a lake that does not contribute surface water flow to a downstream jurisdictional water in a typical year, or is not inundated by flooding from an A1 through 3 water in a typical year would be excluded under B1. An NPDES permit may still be required even if a previously jurisdictional water, such as an ephemeral stream found to have had a significant nexus to a downstream TNW, is not jurisdictional under the final rule. This is because if a pollutant is conveyed through a non-jurisdictional water to a jurisdictional water, an NPDES permit may still be required. Listed on this slide are some examples of waters that may be considered B1 exclusions. I apologize. Now we're going to walk through each of the 12 exclusions in paragraph B. As I mentioned, the first exclusion is B1, waters or water features that are not identified in paragraph A1, A2, A3, or A4. You can think of this as if it's not in, it's out. Listed on this slide are some examples of waters that may be considered B1 exclusions. I do note that this is not an exhaustive list. This includes wetlands connected to a tributary by a non-jurisdictional ditch, such as an ephemeral ditch. Isolated waters that do not meet the adjacent wetlands definition and that are not A1 waters. Upland areas that do not meet the regulatory definition of wetland. Intermittent and perennial losing streams that do not contribute surface flow directly or indirectly to A1 waters in a typical year. Natural lakes and ponds that are not A1 waters, that lack a direct or indirect surface water connection to downstream A1 waters in a typical year and are not inundated by flooding from an A1, A2, or A3 water in a typical year. Impoundments originally constructed in jurisdictional waters, but that no longer contribute surface flow directly or indirectly to an A1 water in a typical year, and that are not themselves A1 waters. And underground or buried portions of a channel network, including culverts and buried streams. The next exclusion is B2, groundwater, including groundwater drained through subsurface drainage systems. The agencies have long interpreted the Clean Water Act as not authorizing jurisdiction over groundwater and have historically excluded groundwater from the definition of waters of the United States. The agencies are retaining this long-standing principle in this final rule. Nothing in the language of the Clean Water Act or its legislative history, Supreme Court interpretations, or past agency practices supports the inclusion of groundwater, including groundwater drained through subsurface drainage systems, in the definition of waters of the United States. This exclusion describes groundwater and shallow subsurface water. It includes groundwater that is drained by subsurface drainage systems like tile drains used in agriculture. Groundwater cannot serve as a connection between upstream and downstream jurisdictional waters. For example, if a perennial stream reach ceases to have an ordinary high water mark and the perennial flow from the stream enters groundwater, such as an aquifer, that groundwater would meet the criteria of the B2 exclusion and not be considered a water of the United States. Additionally, the groundwater cannot act as a hydrologic connection for purposes of preserving jurisdiction of the upstream perennial stream with downstream waters. When groundwater is expressed at the surface, such as where groundwater discharges to the channel bed of an intermittent or perennial stream, that water is no longer considered groundwater at the point it discharges to the surface. The rule discusses subterranean rivers or tunnels, culverts, and structures that bury a portion of a channel network. These underground portions are not considered groundwater and can provide a hydrologic connection between upstream and downstream jurisdictional waters. The B3 exclusion describes ephemeral features, including ephemeral streams, swales, gullies, rills, and pools. The term ephemeral is defined in the rule as surface water flowing or pooling only in direct response to precipitation, e.g., rain or snowfall. Ephemeral flow may occur simply because it is raining or has very recently rained, or it has recently snowed and the snow has melted. Ephemeral flow resulting from a snowfall event is different than sustained intermittent flow resulting from melting snowpack that is continuous, such as for weeks or months at a time. The ephemeral exclusion includes waters that are channelized, such as ephemeral streams and ditches, and transient features like swales, rills, and pools. It is important to note that ephemeral waters can be created as a result of artificial features or man-made manipulations. For example, when a dam is constructed in a jurisdictional water and the dam causes a channelized downstream perennial or intermittent feature to become ephemeral, that channelized ephemeral feature would be non-jurisdictional under paragraph B3, but would not sever jurisdiction of upstream features as long as it conveys surface water flow in a typical year to a downstream paragraph A1 water. The changes made in the final rule to allow for ephemeral streams to maintain upstream jurisdiction so long as they provide a surface water connection to a downstream jurisdictional water in a typical year addresses concerns raised by commenters on the proposed rule about features that would have severed the jurisdiction of relatively permanent upstream portions of the tributary network. It also addresses concerns raised by water management interests that suggested the proposed rule could have inadvertently undermined the NPDES permitting exemption authorized by EPA's water transfers rule. The B4 exclusion describes diffuse stormwater runoff and directional sheet flow over upland. As described in the text of the exclusion, these waters must be located in upland. By their very nature, these waters do not convey channelized surface water flow and therefore cannot serve as a connection between upstream and downstream jurisdictional waters. Some examples of waters that may be considered B4 exclusions include non-channelized flow over upland regardless of the flow characteristics, sheet flow over upland from a lake, pond, impoundment, or wetland to a jurisdictional water, and directional sheet flow over upland during storm events. As we discussed in a prior webinar on tributaries and ditches, the B5 exclusion is for those ditches that are not waters identified in paragraph A1 or A2, and those portions of ditches constructed in adjacent wetlands that do not satisfy the adjacent wetland definition. The term ditch is defined in paragraph C of the rule to mean a constructed or excavated channel used to convey water. It is important to remember that even when ditches are excluded, they do not sever jurisdiction of upstream relatively permanent waters as long as they provide a surface water connection to a downstream jurisdictional water in a typical year. The rule specifically identifies limited scenarios when certain ditches would not meet the B5 exclusion. The first scenario is for ditches that are A1 waters. This rule reiterates the long-standing interpretation that ditches that satisfy any of the conditions of a paragraph A1 water are waters of the United States as paragraph A1 waters. This also includes tidal ditches and ditches that transport goods and services in interstate and foreign commerce, as those ditches, more commonly referred to as canals, provide important commercial navigation services and operate more like natural waters traditionally understood as navigable. For example, ditches such as the St. Lawrence Seaway, the Sturgeon Bay Ship Channel, and the Chesapeake and Delaware Canal are ditches that are A1 waters and are not excluded. The second scenario is for ditches that are A2 waters. The rule retains the long-standing position that the alteration or relocation of a tributary does not modify the jurisdictional status of that water. Accordingly, ditches that relocate a tributary or are constructed in a tributary would be jurisdictional as tributaries so long as they continue to meet the flow requirements of the tributary definition. The third scenario is for ditches that are constructed within the boundaries of an A4 adjacent wetland. If these ditches within the boundaries of the A4 wetland are perennial or intermittent, contribute flow to an A1 water in a typical year, and are not themselves wetlands, the ditch would be jurisdictional as an A2 tributary. Downstream of the A4 adjacent wetland, the ditch would also be considered an A2 tributary as long as the downstream portions are perennial or intermittent and contribute surface flow directly or indirectly to an A1 water in a typical year. Upstream of the A4 adjacent wetland, the ditch would be non-jurisdictional and meet the B5 exclusion regardless of the flow conditions of the ditch, unless the upstream portions of the ditch were A2 tributaries or A1 waters. If these ditches within the boundaries of the A4 adjacent wetland contain wetlands within the ditch, these ditches would be considered part of the A4 adjacent wetland. If the ditch continues beyond the boundaries of the A4 adjacent wetland, wetlands within the ditch would be jurisdictional as A2 waters only in downstream portions where the ditch meets the tributary flow condition. The agencies will use the B5 exclusion to identify excluded ditches unless they serve as a component of another excluded water. For example, if a ditch is part of a waste treatment system, the ditch should be described as meeting the B12 exclusion. Similarly, where the excluded ditch is part of a stormwater system, the agencies will use the B10 exclusion. Note that neither the B5 exclusion nor the B10 exclusion apply to ditches that are jurisdictional waters under paragraph A. Now I'll turn the presentation over to my colleague, Stacey Jensen.
Thank you, Mindy. The B6 exclusion is for prior converted cropland. The definition in the rule means that prior converted cropland is any area that prior to December 23rd, 1985, was drained or otherwise manipulated for the purpose or having the effect of making production of an agricultural product possible. EPA and the Corps will recognize designations of prior converted cropland made by the Secretary of Agriculture. An area is no longer considered prior converted cropland for purposes of the Clean Water Act when the area is abandoned and has reverted to wetlands, as defined in paragraph C16 of this section. Abandonment occurs when prior converted cropland is not used for or in support of agricultural purposes at least once in the immediately preceding 5 years. For the purpose of the Clean Water Act, the EPA administrator shall have the final authority to determine whether prior converted cropland has been abandoned. The rule defines prior converted cropland in a manner that is more expansive than the USDA's definition of prior converted cropland for purposes of the Food Security Act. Additionally, the phrases agricultural products and agricultural purpose in the rule should be applied broadly. Agricultural purposes include land use that makes the production of an agricultural product possible, including but not limited to grazing and haying. Additional examples of agricultural purposes include, but are not limited to, idling land for conservation uses, such as for habitat, pollinator and wildlife management, and water storage, supply, and flood management, irrigation tailwater storage, crawfish farming, cranberry bogs, nutrient retention, and idling land for soil recovery following natural disasters like hurricanes and drought. Notice that the definition of prior converted cropland states that EPA and the Corps will recognize designations of prior converted croplands made by the Secretary of Agriculture. But the agencies may also independently evaluate the prior converted cropland exclusion. That means in cases where a prior converted cropland designation has not been completed pursuant to the Food Security Act, the agencies can evaluate if the prior converted cropland exclusion applies for the purposes of the Clean Water Act based on the definition of prior converted cropland in the rule. For example, if an area was drained or otherwise manipulated for the purpose or having the effect of making production of an agricultural product possible prior to December 23, 1985, and has not been abandoned, the exclusion applies to the wetlands for the Clean Water Act, even in the absence of a Food Security Act prior converted cropland designation. The definition of prior converted cropland clarifies that the exclusion is no longer applicable when the cropland is abandoned and the land has reverted to wetlands. Under the rule, prior converted cropland is considered abandoned if it is not used for or in support of agricultural purposes at least once in the immediately preceding 5 years. The rule also clarifies that cropland that is left idle or fallow for conservation or agricultural purposes for any period or duration of time remains in agricultural use and therefore maintains the prior converted cropland exclusion. Determining if a prior converted cropland has been abandoned should be based on a review of all relevant information, including information from the landowner. Abandoned prior converted cropland would only be jurisdictional if the land reverts to wetland and the wetland meets the definition of an A4 adjacent wetland. Otherwise, the wetland would be non-jurisdictional as another paragraph B exclusion. And finally, it is important to note that a key change from the agency's past practice is that under the final rule, abandonment is the only principle to determine when an area is no longer prior converted cropland. Thus, a prior converted cropland designation applies even if there would be a change in use of the wetland. In other words, wetlands that are determined to meet the prior converted cropland exclusion remain non-jurisdictional even if a change in use has occurred. The B7 exclusion describes artificially irrigated areas, including fields flooded for agricultural production, that would revert to upland should application of irrigation water to that area cease. Remember that the definition of upland is defined in the rule to mean any area that under normal circumstances does not satisfy all three wetland factors and does not lie below the ordinary high water mark or the high tide line of a jurisdictional water. The relevant factor in determining the application of the exclusion is not what type of crops may be planted or cultivated, but whether the area is artificially irrigated and would revert to upland should irrigation cease. In last week's webinar, we discussed when lakes, ponds, and impoundments of jurisdictional waters are waters of the United States as A3 waters. The B8 exclusion covers artificial lakes and ponds, including water storage reservoirs and farm, irrigation, stock watering, and log cleaning ponds, so long as those artificial lakes and ponds are not impoundments of jurisdictional waters that meet the conditions of paragraph C6. In order for the exclusion to apply, the water must have been constructed or excavated wholly in upland or in non-jurisdictional waters. The list of waters identified by the exclusion are not limited by the examples provided in the description. The exclusion is applicable to a diverse range of artificial lakes and ponds. This exclusion applies to artificial lakes and ponds even if the waters have a surface water connection to a downstream jurisdictional water in a typical year, or are inundated by flooding from an A1 through A3 water in a typical year. Artificial lakes and ponds constructed by impounding non-jurisdictional waters are excluded under B8. The rule also provides that impoundments originally constructed in jurisdictional waters may become hydrologically isolated without a surface connection to downstream jurisdictional waters. Where this occurs, the impoundment would be excluded under B1, as the B8 exclusion would not apply. The B9 exclusion includes water-filled depressions constructed or excavated in upland or in non-jurisdictional waters incidental to mining or construction activity, and pits excavated in upland or in non-jurisdictional waters for the purposes of obtaining fill, sand, or gravel. Like the B8 exclusion, in order for the exclusion to apply, the water must have been constructed or excavated wholly in upland or in non-jurisdictional waters. The rule explains that the exclusion is specific to activities associated with mining or construction. In addition, the exclusion does not apply once the specific construction or mining activities have permanently ceased. At this point, such water-filled depressions and pits could be determined to be waters of the United States if the waters meet the conditions of a paragraph A1 through 4 water, or they could be determined to meet another paragraph B exclusion, such as B8. The B10 exclusion describes stormwater control features constructed or excavated in upland or in non-jurisdictional waters to convey, treat, infiltrate, or store stormwater runoff. Like B8 and B9, in order for the exclusion to apply, the water must have been constructed or excavated wholly in upland or in non-jurisdictional waters. Stormwater control features have evolved considerably over time, and their nomenclature is not consistent. So in order to avoid limiting the exclusion, the rule excludes the diverse range of stormwater control features that are currently in place and may be developed in the future, as long as they convey, treat, infiltrate, or store stormwater runoff. The rule recognizes that a stormwater management system that is constructed in upland or in non-jurisdictional waters may be connected to jurisdictional waters, and that such a connection does not preclude application of the exclusion. Additionally, a stormwater management system may utilize otherwise jurisdictional waters, such as channelized tributaries, and these otherwise jurisdictional waters would remain jurisdictional if they continue to meet the flow conditions of the tributary definition. For example, the Los Angeles River is a traditional navigable water highly engineered for stormwater control, and it still meets the requirements of a paragraph A1 water. Stormwater control features constructed or excavated in upland or non-jurisdictional waters remain excluded even if the waters have a surface water connection to a downstream jurisdictional water in a typical year, or are inundated by flooding from an A1 through 3 water in a typical year. However, the preamble notes that excluded stormwater control features with channelized surface waters do not sever jurisdiction of an upstream relatively permanent water, as long as they provide a surface water connection from the upstream water to a downstream jurisdictional water in a typical year. Examples of waters that may be considered B10 exclusions, where they meet the requirements of the exclusion, include storm sewers and detention and retention ponds, green infrastructure, and ditches that are part of a stormwater control system, so long as the ditches do not meet the terms of paragraph A. The B11 exclusions describe groundwater recharge, water reuse, and wastewater recycling structures, including detention, retention, and infiltration basins and ponds, constructed or excavated in upland or in non-jurisdictional waters. Like B8, B9, and B10, in order for the exclusion to apply, the water must have been constructed or excavated wholly in upland or in non-jurisdictional waters. The exclusion includes detention and retention basins, as well as groundwater recharge basins and infiltration ponds excavated in upland or in non-jurisdictional waters for wastewater recycling. The exclusion also covers water distributary structures that are built in upland or in non-jurisdictional waters for water recycling. These features often connect or carry surface water flow to other water recycling structures, for example, a channel or ditch that carries water to an infiltration pond. The water distributary systems would also meet the exclusion provided they were constructed in upland or non-jurisdictional waters. Although these features must be constructed or excavated in upland or non-jurisdictional waters, they are often located in close proximity to tributaries or other large bodies of water. These excluded waters do not sever jurisdiction of an upstream, relatively permanent water, as long as they provide a channelized surface water connection to a downstream jurisdictional water in a typical year. The B2 exclusion for groundwater is distinct from the B11 exclusion for groundwater recharge, water reuse, and wastewater recycling structures. Paragraph B11 in the final rule is focused on features that are used to collect and store water prior to beneficial reuse, as opposed to groundwater more generally. This rulemaking does not change the requirement that a point source discharge of pollutants to a water of the United States must be authorized by a Clean Water Act Section 402 permit. For example, if excluded wastewater recycling structures discharge pollutants to a water of the United States, those discharges could require an NPDES permit. The B12 exclusion is for waste treatment systems, one of the agency's long-standing exclusions. As defined in the rule, the term waste treatment system includes all components, including lagoons and treatment ponds, such as settling or cooling ponds, designed to either convey or retain, concentrate, settle, reduce, or remove pollutants, either actively or passively, from wastewater prior to discharge, or eliminating any such discharge. This exclusion applies only to waste treatment systems constructed in accordance with the requirements of the Clean Water Act, and to all waste treatment systems constructed prior to the 1972 Clean Water Act amendments. For example, if the system was built in a WOTUS with a 404 permit for the discharges of dredged or fill material to create the system, and the system is covered by a 402 permit for discharges to a WOTUS, such a system would be excluded from the definition of WOTUS under B12. Typically, in this situation, a project proponent would need to mitigate for any loss of Clean Water Act jurisdiction when obtaining the 404 permit for construction of the waste treatment system. If the system was built prior to 1972, it would need a 402 permit if it is currently discharging to a WOTUS. If a waste treatment system is abandoned or otherwise ceases to serve the treatment function for which it was designed, it does not continue to qualify for the exclusion. It's important to note that the waste treatment system exclusion applies to waters regardless of whether they meet the jurisdictional requirements of paragraph A1 through A4 waters, or were constructed or excavated in jurisdictional waters. For example, impoundments of jurisdictional waters that are used for waste treatment systems are excluded so long as the waters are used for their permitted purpose. However, similar to other exclusions, a determination that a water meets a B12 exclusion does not sever jurisdiction of an otherwise jurisdictional water upstream, so long as the waste treatment system conveys channelized surface water flow to downstream jurisdictional waters in a typical year. The exclusion continues to apply even where a waste treatment system is modified over time, as long as it continues to be used for a treatment purpose. The exclusion applies to systems that are treating water to meet the requirements of the Clean Water Act, and discharges from these systems to waters of the United States would continue to be subject to regulation by the Clean Water Act under the Section 402 permitting program if they discharge to a jurisdictional water. Continuing long-standing practice, any entity with a proposed waste treatment system would need to comply with the Clean Water Act by obtaining a Section 404 permit for new construction of a waste treatment system in a water of the United States, and a Section 402 permit for discharges from the waste treatment system into waters of the United States. Determinations as to whether stormwater treatment features may fall within the exclusion for stormwater control features or the waste treatment system exclusion will depend on the specific attributes of the control and the water feature, and so will need to be made on a case-by-case basis. Examples of waters that may be considered B12 exclusions, where the requirements of the exclusion have been met, include cooling ponds created to serve as part of a cooling water system with a valid state or federal permit constructed in waters of the United States, tidal waters that are part of a waste treatment system, wetlands that develop within a waste treatment system, and intermittent and perennial ditches that are part of a waste treatment system, including ditches that would otherwise be jurisdictional under paragraph A. Now that we have covered waters that are excluded from the definition of waters of the United States, we would like to cover the jurisdictional determination process conducted by the Corps, as questions have arisen during other webinars. The Corps has long provided jurisdictional determinations, or JDs, as a public service. The Corps recognizes the value of JDs to the public and is committed to continue its practice of providing JDs when requested to do so. A JD is a written Corps determination that a water is subject to regulatory jurisdiction under Section 404 of the Clean Water Act, or a written determination that a water is subject to regulatory jurisdiction under Sections 9 or 10 of the Rivers and Harbors Act of 1899, as defined in the Corps' regulations at 33 CFR 331.2. For today's presentation, we will be focused on JDs made in the context of the Clean Water Act. All JDs are in writing and are identified as either preliminary or approved. JDs are typically made at the request of a landowner or project proponent in the context of the Clean Water Act. JDs do not include determinations that a particular activity requires a Department of the Army permit. The Navigable Water Protection Rule does not change or modify the Corps' implementing regulations regarding the definition of JD or the types of JDs the Corps offers. EPA also decides the extent of Clean Water Act jurisdiction for a variety of purposes. EPA decisions on jurisdiction are not approved JDs as defined and governed by the Corps regulations at 33 CFR 331.2. EPA has final administrative authority over the scope of Clean Water Act jurisdiction, as specified in the 1979 U.S. Attorney General opinion, more commonly known as the Civiletti Memo. Note that states may choose to make determinations of whether a water is a water of the state for state programmatic purposes, but those determinations may differ from waters of the United States. Many times, a landowner or permit applicant submits information, such as a delineation of water's presence on the site, to the U.S. Army Corps of Engineers, which the Corps then reviews and uses in conjunction with various other sources of information, which may include a field visit to issue a JD. A landowner or applicant can decide whether they would like an approved jurisdictional determination or would prefer a preliminary jurisdictional determination, or JD. A preliminary jurisdictional determination, or PJD, is a non-binding written indication that there may be waters of the United States on a parcel. An applicant can elect to use a PJD to voluntarily waive or set aside questions regarding Clean Water Act jurisdiction over a particular site, and thus move forward, assuming all waters will be treated as jurisdictional without making a formal determination, usually to proceed more quickly to obtain a Corps permit decision. PJDs cannot determine that something is not a water of the United States and/or that there are no waters of the United States on the site. An approved jurisdictional determination, or AJD, is an official Corps document stating the presence or absence of waters of the United States on a parcel, or a written statement and map identifying the limits of waters of the United States on a parcel, AJDs will include a basis of jurisdiction, providing indicators that support the determination. In order to conclude a water is non-jurisdictional, the Corps must complete an AJD. Corps AJDs are generally valid for 5 years, unless new information warrants revision or a district engineer identifies specific geographic areas with rapidly changing environmental conditions that merit reissuance on a more frequent basis. That is described in more detail in the Corps' Regulatory Guidance Letter 05-02. AJDs are appealable actions, while PJDs are not. Jurisdictional determinations are not required in all cases. The Corps may authorize an activity with a general permit, letter of permission, or standard permit without issuing an official JD of any type, as long as the circumstances do not necessitate an approved JD. The vast majority of Corps permit actions do not involve AJD. Most Corps permit actions are supported by a PJD or are completed with no JD whatsoever. The Corps has developed an interim AJD form for AJDs made under the Navigable Waters Protection Rule. The rule is currently in effect in all states and jurisdictions, except for the state of Colorado, and thus the Corps is using this form everywhere except for Colorado. They have also developed an interim approved jurisdictional determination form user manual, which provides instructions to Corps field staff on how to complete the interim form. The AJD form generally provides the basis for jurisdiction as required in the definition of JD. The agencies recognize that the Navigable Waters Protection Rule could affect AJDs issued prior to its effective date, as discussed in the preamble to the final rule. As I stated earlier, as a matter of policy, AJDs are typically valid for a period of 5 years. The possessor of a valid AJD may request that the Corps reassess a parcel and grant a new AJD before the 5-year expiration date. A Corps AJD constitutes a final agency action pursuant to the agency's definition of waters of the United States at the time of its issuance. The Navigable Waters Protection Rule does not invalidate an unexpired AJD that was issued prior to the rule's effective date. As such, these AJDs will remain valid until the expiration date, unless one of the criteria for revision is met under the Corps' Regulatory Guidance Letter 05-02, or the recipient of such an AJD requests that a new AJD be issued pursuant to this final rule. If you would like additional information about jurisdictional determinations, this slide lists different resources, including the Corps' applicable regulations, the Corps' Regulatory Guidance Letter 16-01, which addresses jurisdictional determinations, and the Corps and EPA's jurisdictional determination websites. Please note that the Corps and EPA AJD websites do not include information on the full extent of waters that are or are not jurisdictional. Only those waters for which the agencies have made a definitive determination of a water's jurisdictional status. The EPA's website contains AJDs finalized since August 28, 2015. The agencies are undertaking several specific efforts to enhance implementation of the new rule. EPA and the Army are developing several joint memoranda to help facilitate implementation of the final rule. The 3 memos listed on this slide are currently undergoing EO 12866 interagency review or have recently cleared OMB review. The agencies have considered or will consider the interagency comments they receive before finalizing the memoranda and will post the final memos to their websites. The purpose of the elevation and coordination procedures for certain determinations under the Clean Water Act, or the TNW memo, is to ensure the consistent implementation of the Navigable Waters Protection Rule by establishing a process by which EPA, Army, and the Corps will elevate to their headquarters for coordination certain determinations under the Navigable Waters Protection Rule regarding paragraph A1 waters. And this memo has cleared interagency review and will be released soon. The purpose of the memorandum to the field on exemptions from regulation under Section 404 F1C of the Clean Water Act for the construction or maintenance of irrigation ditches and for the maintenance of drainage ditches, or the ditch exemptions memo, is to provide a clear, consistent approach regarding the application of the exemptions from regulation under Section 404 F1C of the Clean Water Act for the construction or maintenance of irrigation ditches and for the maintenance of drainage ditches. And finally, with USDA, the agencies are developing a memorandum to the field concerning implementation of the Navigable Waters Protection Rule under Section 404 of the Clean Water Act and the Food Security Act of 1985. The purpose of this memo is to minimize duplication of efforts pursuant to the Clean Water Act Section 404 program and the Food Security Act wetland conservation provisions, and facilitate the agency's efforts to ensure that federal wetland programs, including those that identify prior converted cropland, are administered in an efficient and effective manner. And this memo will replace the 2005 Corps and USDA memo, which was jointly rescinded in January 2020. This memo has cleared interagency review and will be signed soon by the agencies. In addition to the three memoranda listed on this slide, the agencies are also developing a memorandum to the field on coordination to ensure consistent implementation of the Navigable Waters Protection Rule. This memo will ensure the consistent implementation of the rule by establishing a process by which EPA, Army, and the Corps will coordinate on policy matters. As we move forward with implementing the rule, the agencies will consider other guidance, FAQs, or whether we should update existing guidance, if and as necessary, to facilitate implementation of the Navigable Waters Protection Rule, both initially and as the agencies gain field experience to address implementation questions that may arise. Any such guidance will be developed in compliance with Executive Order 13891 and with any applicable public participation requirements. In the preamble to the final rule, we provided some background on our interest in aquatic resource mapping, and we'd like to update you on the progress we've made on this effort. During extensive outreach on the proposed rule, stakeholders indicated that maps of jurisdictional waters could increase certainty and transparency regarding the data and methods used to determine which waters are jurisdictional and which waters are not. There are currently no comprehensive data sets through which the agencies can depict the universe of federally regulated waters under the Clean Water Act. The EPA and the Army have been engaging with the Department of Interior to discuss using existing geospatial data sets to map the nation's aquatic resources, including both waters of the United States and non-jurisdictional waters. To align the agency's Water of the United States mapping interests with DOI's established aquatic resource mapping efforts, including the National Hydrography Dataset, or NHD, and the National Wetlands Inventory, or NWI, the EPA and the Army have engaged the U.S. Geological Survey and the U.S. Fish and Wildlife Service to establish a technical working group to develop strategies that can address their Clean Water Act mapping needs. EPA and the Army believe the most efficient way to address their regulatory needs is to better align their efforts with DOI's existing processes and national mapping capabilities. The EPA, USGS, and Fish and Wildlife Service have a long history of working together to map the nation's aquatic resources. In addition, the Corps has engaged to provide technical support with respect to its expertise in determining jurisdiction under the Clean Water Act. In this effort, the EPA and the Army are collaborating with DOI to enhance the mapping of the nation's water resources and to begin a process to better identify waters of the United States through the development of an aquatic resource decision support system. And we appreciate the support we've received from both USGS and Fish and Wildlife Service on this long-term effort. This concludes our discussion of exclusions from the definition of waters of the United States and our state and tribal webinar series. For more information about the two-step rulemaking process, the published Federal Register notice, and the supporting analyses and fact sheets, we encourage you to visit EPA's website listed on this slide. We will also be posting the recording of this webinar on the website shortly. A recorded presentation providing an overview of the rule is available on EPA's YouTube channel. And questions can be sent to either EPA or Corps' email boxes. Thank you. I will now turn it back to Mr. Owen McDonough.